This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Because OMR mismatch tinted. OMR has been
blank OMR.
fraudulently has been done.
Blank OMR.
Hard OMR blank is also tinted. In addition to that, this is also there.
That might be there.
I mean, tinted is a broad term.
Yes, because these are what court is saying that paragraph 363, or the main paragraph of judgment dated 22nd April 2024 of the division bench, where it is stated that there are three categories of tainted. That is the probable categories, not all categories.
My humble
not all
submission,
categories.
My humble submission, this is the interpreted by the division.
To pinpoint all the categories of
division bench has pinpointed
that from the division bench, when the bench presided over Justice Basa, and also the Supreme Court, the tainted candidate in one case, it has been given the chart has been given. OMR, these are on the basis of the CBI. Right?
Yes.
These are all tainted. Second is beyond the panel which who have been taken. Rank jumping. I was forgotten one. Jumping was also.
I am not rank jumping. I have shown the list of rank jumping.
Rank jumping was also tainted. Rank jumping was also tainted.
Persons who had been appointed outside the panel.
What I am saying, in addition, these are the
outside the panel includes rank jumping.
It cannot be.
That is the.
It cannot be said. OMR mismatch is not tainted. Blank OMR is not tainted. OMR mismatch is
blank OMR is tainted.
And also submitted blank OMR.
Yes,
blank OMR was classified as tainted under paragraph 363(4).
Yes, not that is. But here, what you want to say. That we are not.
Mr. Lahiri wants to say that there are only three categories of tainted candidates.
No.
Under paragraph 363(4). What are those categories? Candidates appointed beyond the panel, candidates appointed outside the panel, and candidates who submitted blank OMR.
But then in that case, OMR mismatch is not.
Blank OMR and OMR mismatch is totally different.
OMR
mismatch is a 1 marks also.
OMR mismatch is the greatest tainted candidates. Everything has been fallen because of the OMR mismatch.
Now, my lord, I'll show
OMR
your lordship.
And
may I complete, my lord? Our senior friend will get.
Mr. Light, this is not nothing to be talked much. We are also facing the courts also. Let me be very clear. We are treating them as a tainted. We are treating them as a tainted.
But persons who are supposed to be treated as tainted is not being treated as tainted.
You challenge that.
I have challenged here and now.
Let them party and come back. Then we will see to that.
In either of the litigations.
Now, yesterday, although I was not there, I have received the instructions from my advocate on record. Yesterday also, one of the matter was taken up, and other petitions have been dismissed. One there we have said. They have shown, it will be very clear to your lords if I say that there are mismatching of the list of the tainted and a CBI start, which we have said the list which has been published by the SSC, that they were all appointed, right? And the difference between that, they are also tainted. We are also cancelling their admit cards also. And we have said also, there may be some, everything is not filtered at 5 lakhs applications are there. It may not, but ultimately, if anyone is there, we'll cancel. And because this is the order of your lordship's order, which has been upheld.
That is what I'm saying.
Be treated. They cannot be accepted at all.
That is what I'm.
Even if I miss anywhere, let's assume. If I miss anywhere, that here I'm missing. He has got it.
At the time of verification.
At the time of verification, I will do it.
But that is what I'm saying. If I appear in the examination,
if you appear in the examination, Supreme Court
kindly cancel me. Kindly cancel. I will get an opportunity. I want to go to Jamuna. I want to go to, but after appearing in the examinations, not like this. No, if I miss examination, I will not be able to appear. 156 has not been accepted. 156 has not been accepted.
See, below.
156 has not been accepted.
Table 1.
Let us, yes, see.
Just a minute.
156 of the writ petition.
Supreme Court order. Lordship is taking the Supreme Court order as paragraph.
3rd April 2025 order.
Yes. 156 minus second volume order.
Paragraph?
Paragraph 25, page 150.
Just a minute.
First similar, in the written submission filed on behalf of WPSSC in this court, two tables have been furnished. Table 1 pertains to candidates who are...
Just a minute, just a minute.
Lordship, kindly see, these are the submissions which have been recorded.
In the written submission filed on behalf of the WPSSC in this court, two tables have been furnished. Table 1 pertains to candidates who earlier jumped rank, were appointed despite not being in panel. The details are assistant is 74 rank jump, out of panel but still appointed at 111. Assistant teacher for class 11, 12, 20, out of panel but still appointed 18. Well, this is the 9 and 10, that's the written answer. Then table 2 fund is the WPSSC for candidates who are appointed by manipulating the OMR states. Table 2 is as under.
Table 2 assistant teachers plus...
OMR score mismatch for CBI made.
Where you are getting the manipulating this? Yes.
Who are appointed by manipulating the OMR states.
But these are the submissions.
No.
I'll show. These have not been accepted.
What is tainted?
Kindly see paragraph 28.
Therefore, kindly see and answer 952. Then assistant teacher, candidate who are appointed, I will not show. Assistant teacher for class 9 and 7. Then, in another, it is a filed on behalf of in this court. It is claimed that on further verification, the following details of the candidates who either jumped rank or were appointed despite not being in the panel came to light. Rank jump 74, loss of particular.
Next, table 2.
Next.
Paragraph 26.
Paragraph 26. 26. Table A, table B.
Yes.
Therefore, these are tainted. Why the Supreme Court has said all tainted?
Kindly reads.
Remove.
Kindly reads on.
Just 1 minute.
Yes.
No,
accent. I understand. I know.
3 minutes. Therefore, these all were terminated. Number 1. Then the Supreme Court will file the applications for all. I mean, both file the application for group 910, 910 LLC and SC. Supreme Court has said, we are allowing you to keep this for the timing. Number 1, up to 31st December, you have to complete the examination. Number 2, no tainted candidates should be allowed to apply. First, he has not challenged the termination. Second, he has not.
There is no termination as such, as of today.
Cancellation of appointment.
There is nothing.
By Supreme Court.
Nothing. That is by Supreme Court. Thereafter, it has not been indicated to us. Where is the cause of action? How will I come and say?
Don't come. Don't be excited.
In this matter, don't raise your voice.
Second, my lord. Second is
my leader. He knows everything.
Lordship has pointed out. Already pointed out. You have not been allowed to join. After 31st December. Why did you not?
Where is that order that candidate 17th? This is 17th April.
17th April is page 175. 175. Now, kindly, before going there, kindly come to page, paragraph. No, একটা কিছু না, আমি শেষ করব, বলেই দিয়েছে শুনুন।
May I read it? We are trying to accept 175.
17th April order.
Page 175.
Yes. The examination and the inter-recruitment process shall be completed by 31st December. Then paragraph 3, the state government and the applicant
shall file the respective evidence by 31st May 2021. Copy of the advertisement for the press recruitment as well as the civil therefore so as to ensure completion of the recruitment process by 31st December 2000. In case the advertisement is not passed by press transport are not filed by the court, they will have to put it order to be passed by the court. Clarify this order cannot be read as a conferring any press. We are not inclined to accept the prayer in the present
TD. TD.
No. Oh.
But where is the
Yes, sir. We are inclined to accept at the top line of the order or of the order first beginning. We are not inclined to accept the prayer made in the present application so far as not found to be tainted subject to the following. And last.
So this is the prayer made by the West Bengal Board of Secondary Education.
Board.
Yes. Permitting them to permitting the untainted to work.
Now,
that was accepted.
They filed an application to allow everyone. Board Supreme Court has said no. Kindly come to the last lines.
That is CD. That is CD. That is CD.
This order in respect of action not found to be tainted in that student undergoing study.
Which paragraph?
Last part 1. Page 176.
That is in connection with Group C, Group D.
No. After that. What has prompted us to pass this order? In respect of the assistant teachers.
Just it. Place it, which paragraph?
Just come to 176. That's why come to 176.
You are on the order date 17th April 2025. Passed on miscellaneous application 709 of 2025.
Yes.
Which paragraph you are relying upon?
Let this page, can you come to next page?
Yes.
176.
There are 1, 2, 3, 4 paragraphs.
After that, we clarify that these orders cannot be read as a confirming any special right or advantage on the associate teacher in so far as the press recruitment process is concerned. That is untainted. Then we are not inclined to accept the prayer in the present application so far as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in the said group is substantially high. And secondly, what has prompted to us to pass this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of the lack of teachers and the lackness and failure, which have resulted in the order passed by this court.
So that after this this observation, we were not permitted. After this observation, you were not permitted. After this observation, you were not permitted to work.
I am not.
Which goes to show that you are considered as tainted.
That is the interpretation. We have not been informed of anything.
Yes,
we have not been informed. This is for the first time it appears that our names have been taken into account. And Mr. Bandyopadhyay has shown paragraph 25 kindly comes to paragraph 28 of that Supreme Court. That your lordship is seeing the Supreme Court from your lordship's brief, Malad. Your lordship's brief, Malad. Your lordship is having Supreme Court alada kore. Yes, that one.
Yes, there are only 363 paragraph.
Now, Malad, no, not 360. The Honorable Supreme Court judgment, main judgment.
Yes,
paragraph 28. Kindly see paragraph 28 because Mr. Bandyopadhyay has shown, Malad, the submissions, which starts from paragraph 25. Submissions, the charts. Now, in view of the fact that the charts were contradicting and the charts have been subsequently improved and all these things, that is the finding of the Supreme Court. Kindly see what the Supreme Court holds. Paragraph 27. From that, at this stage, we would like to kindly skips paragraph 28 at internal page 31 of the judgment. I'm sorry, Malad, I'm traveling with Lordship, Malad.
Yes, paragraph 20.
We may have accepted this argument
Yes.
if WBSSC had the original physical OMR sheets or the mirror copies of the OMR sheets. So the previous arguments are not being accepted. Chart also. However, WBSSC accepts that they do not have the physical OMR sheets as they were destroyed in terms of Rule 21 of the classes such and such, which required retention of OMR sheets for only 1 year. Rule 21 of the such and such, well, it is quoted thereafter. Admittedly, the OMR sheets who have been applied for non-teachings. Well, I'm keeping that relates to non-teaching. Thereafter, paragraph 30. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. It is apparent that the time period specified in Rule 21 was coincide with the time period specified for validity of the panel. Further, WBSSC did not maintain the mirror copies of the OMR sheets in their computer records. Thus, the destruction of the physical OMR sheets and the failure to maintain scanned images of the OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. Thereafter, paragraph 31 that I have already placed, WBSSC has also tried to justify the extension of the term of the panel as noted above. The term period of 1 year specified in such and such for destruction of OMR sheets coincides. There is no doubt that the counseling process and the appointments made to the post of assistant teachers were made after the expiry of panel. That matter I have indicated to your lordship what is the list that they have given before the division bench. They have not been put in the tainted list. It is illegal. This is illegal and contrary to the rules. Reliance on the orders stroke judgments of the High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after the expiry of validity panel, would not have any significance. So therefore, Supreme Court deprecates the persons who have been appointed after the expiry of the panel. And the list is there before a lordship. And I can substantiate at least one candidate, and I can substantiate the entire list. None of the names of this list who have been appointed in the 8th round of counseling, which was held on 3rd August 2020, have been included in the tainted list. And we are outside. We have been included.
Yes. Yes, that's all.
Now, my lord, kindly, this list I have shown to you.
Yes, Mr. Sen.
And my lord, another point.
Yes.
1%, my lord, another, my lord, item number 4 is different. Kindly, my lord, takes up item number 4. Item number 4. 7 and 4 is on the same. Kindly gives me 1 minute time. I'll place item number 4 because there the affidavit of the SSC says in the first round of litigation that these persons are not tainted. It says I'll rely upon that one. 19. That is also 4 is also 19. And the only distinction feature between 910 and 1112 is in 910 the OMRs were published. But in 1112, the OMRs were directed to be published by the Honorable Justice Abhijit Gangobadhyay. We moved, my lord, an intra-court appeal that was stayed, and the Honorable Supreme Court directed that only the names will be published, the OMRs. So the 1112 candidate, as of today, do not know what is their OMRs. There is a direction in the Honorable Division Bench, presided over Justice Devanshu Vasak's judgment, to publish the OMRs.
Item number 7 is relating to 910. Basically, points are saying what your lordship is interpreting paragraph 363 of the division bench order. Your lordship's view is that is only illustrative. That is not exhaustive. But I would like to just read paragraph 363 with the Supreme Court judgment to show that that 3 becomes exhaustive because of only the fact that the Supreme Court was of the view that there was no original MR sheet. Also, OMR sheet, there was no original which was, and the originals were destroyed. So therefore, it was not, and there were several disputes raised with regard to the scan and the mirror copies.
Yes.
So therefore, it cannot be said with certainty that other irregularities concerning the OMR sheet. So therefore, what could be said is that blank OMR sheet. That is something which is conclusive to make it within the category of tainted. But whether the other irregularities relating to the OMR sheet will also fall within the tainted category, for that one has to come to a conclusive conclusion. Yes, this is the copy which is produced in the original, or it is exact copy of the original.
Whether the petition is working?
No. December 31. That is
not
there.
Working.
Not working.
So what steps you did?
But that I understand. But here, my lord.
No. What you understand? Why steps were not taken?
Yes, well, that is what I wanted to answer, my lord. Your lordship.
That others are permitted. Why you are not permitted?
But that I was not part of the Supreme Court.
No, that is not required. You are not part of. When you are not permitted to work till 31st of December, you should have approached the authority for taking steps. That why I am being I am not being permitted to work till 31st.
Because then they will show that this
31st of December 2025.
That the Supreme Court ordered that is going to be cited.
Yes. So therefore, you are being treated as untainted. From the after the list was prepared containing names who are permitted to work till 31st December.
Well, this does not categorize or segregate the tainted
or untainted. It goes to show that you are being treated as tainted candidate.
Well, your lordship will kindly
only those candidates who are treated as only those candidates who are treated as untainted were permitted till 31st of December in terms of the order dated 17th of April.
Well, with the greatest of respect, well, that division, if it was already possible, then the Supreme Court would not
for that, Mr.
would
Sen,
not have cancelled the entire process.
There was no requirement to wait till publication of this list.
No, because I have already got the admit card. Before publication of the list, they treated me as untainted, and they gave me the admit card. So then, my lord, where is my cause of action? Very well, I was not working, but provision was made for appearance in the next exam, next recruitment process. I was allowed to participate in the next recruitment. Admit card is already given. But how will I know that a different list of untainted and tainted will now be segregation?
Approach the Supreme Court in an IA in a pending matter.
Well, kindly.
Since Supreme Court is in session of the matter,
now,
why court will consider?
Therefore, now comes the balance of convenience. Your lordship will see if the exam is on Sunday. So, my lord, if even after the exam, my fate can be decided. Even after the exam, my fate can be decided. My answer may not be considered or whatever. But today, if a firm decision is taken without there being active segregation of this distinction of tainted and untainted, then, my lord, my right will be lost forever. Yes. There is a question of balance of convenience. But here, that is why I just want to refer to 363, why that is exhaustive. That is exhaustive because of the Supreme Court judgment. Just the paragraphs which Mr. Lahiri has placed, that is extremely relevant. Kindly just see once, Your lordship kindly sees paragraph.
Yes, that has been placed. I have seen.
No, I am not on that. I am saying, I am therefore saying that Supreme Court definitely came to the conclusion that first of all, there is destruction of original. Second, whatever copy is being produced, there is substantial cloud. If there was no substantial cloud, then...
So in your case, admit cards were issued, then thereafter you were enlisted as tainted.
My case also. Thereafter I have been enlisted as yes, admit card has been cancelled. Cancelled. Has been cancelled. That is what I have challenged here, Ballard.
I have not shown the cancellation of the admit cards. I can show it in the cancellation screenshot.
Is any addition by anybody?
Item number.
I rest my submission.
This candidate, this particular Malord teacher was Malord working, and her services were not terminated intact, but has been terminated pursuant to order of the Honorable Supreme Court. In that matter, Malord, an affidavit was filed by the
Supreme Court 3rd of April.
Yes. Not working after 3rd of April. Now, page 62 is the affidavit which has been filed by the SSC before the single bench, which ultimately went to the Supreme Court. There, the SSC had said, but what the mismatch of marks, my lord, were there in respect of this particular candidate was to the tune of only 1 mark. The OMR sheet, if evaluated, would come to say 20. I have been given, would come to 19. I have been given 20. That is the only 1 mark. The SSC said, in respect of this particular candidate, kindly comes to, may I just place paragraph 63, page 63, first paragraph. Second paragraph. Secondly, in respect of
your that petition
of yes, item number 4. But this was never placed nowhere in the previous rounds of litigations. Those are mirrored on the points of principle.
Therefore, this court finds these are not fit cases where court should interfere with the lists dated 30th August 2025 containing names of tainted candidates. When the Honorable Supreme Court is insisting of the matters as aforesaid. Next paragraph. Hence, writ petitions stand dismissed. However, there shall be no orders to cause urgent relaxation.
Well, 2 points, my lord, that the expiry panels are being continued and not included in the tainted list in view of paragraph 31 of the Supreme Court order, my lord. Kindly, well, I have made submissions that these persons who are expiry panel candidates have not been included in the tainted list, and my lord, in respect of which paragraph
expiry panel candidates,
paragraph 31 of the Supreme Court order, where the Supreme Court has severely deprecated these persons are continuing. I am given the list also.
Paragraph 31.
31.
Yes, I have considered paragraph 31, that
yes,
is rank jumping.
Rank jumping, but these candidates are continuing.
Where the High Court directed to appoint candidates after expiry of the validity of the panel, but
these are
the Supreme Court found this is not a significant issue.
This is a significant issue. These illegalities and contrary to rules.
Jumping, where the High Court directed to appoint candidates after expiry of the validity of the panel would not have any significant impact.
Yes, significant impact. Some of these persons had secured.
It would not have any significant
impact. That is, some of these candidates had shown orders by which they were directed to be appointed. That didn't have any significant impact. Because these candidates, 1 or 2 candidates, they had orders passed by the Honorable.
I have recorded your submission based on observation made in paragraph 31 in my own way.
31. Lashe also record that persons who are expiry, because this will be
not that I have ignored your submission in connection with paragraph 31 of the judgment dated 3rd of April 2020.
Only one submission was that these are expiry panel candidates, they are also being continued. Kindly record 1 line. This is my contention, and this will be appearing from the
expiry panel.
After expiry of the panel, because we were appointed in 2018. panel was valid till end of 2019. These candidates, counseling was done in August 2020. So after expiry of panel. And
So
these,
they were allowed to continue.
they are allowed to continue. They are not even in the tented list. Yes, yes, they are in the CBI list. Everyone is there.
আচ্ছা ওখানে ওর যে সাবমিশন
Page 117.
রেকর্ড করেছে সেখানে একটা লাইন অ্যাড করো তো those candidates
Yes.
please allow me to record it. Yes. Some of the candidates some of the candidates were allowed to continue, but they were appointed after expiry of the
Panel.
relevant panel.
Yes. List, page 107.
After expiry of the panel.
Panel.
After expiry of the panel.
List is 117.
And their names do not feature
In the
in
tented.
the list dated 30th August 2024.
We have excluded anybody whose name appeared in the CBI system.